This is the matter of Patricia M. Dunn v. Genzyme Corporation, SJC-12904.
Mr. Doherty.
Thank you, Justice Gaziano and Associate Justices. May it please the court. My name is John Doherty. I represent the appellant Genzyme Corporation. The issue before the court today is a narrow one. Does Mrs. Dunn's amended complaint pass muster under the pleading standard established by this court in Yannickino in her attempt to assert one or more causes of action against Genzyme that would otherwise be preempted by federal law? It does not pass muster. Congress has created what's been called a narrow gap into which a plaintiff's state law claim must fit in order to escape preemption. That doctrine required Mrs. Dunn's amended complaint, which, by the way, was filed after she was on notice of the preemption issue, to allege facts plausibly suggesting A, that Genzyme violated a federal law or regulation, B, that alleged violation would be actionable under Massachusetts law. In other words, it would be identical or equivalent to a cause of action in Massachusetts. And of course, thirdly, that there'd be some nexus between the alleged violation and the alleged injury. Those facts are not present in the complaint.
Attorney Doherty, I just want to ask, before you get into that, assuming we say that the complaint's not sufficient, what would prevent Ms. Dunn from amending her complaint or requesting to amend her complaint?
Well, we've argued, Justice Budd, that it would be futile. When the original complaint was filed, there was lots of publicly available information for her to draw on in order to try to support the allegations with facts. When the amended complaint was filed, she was on notice of the preemption issue. And as we argued to Justice Buckley at the Superior Court level, any attempt to amend the complaint at this stage would simply be futile because the facts would not plausibly suggest that there is a cause of action under the laws of the Commonwealth against Genzyme.
So you're saying that there's no way to prove it. There's information out there, but that's not going to help her.
The information that has been cited, the information that we're aware of would not help her, Justice, but that is our position.
Okay, thank you.
Justice Lowy, then Justice Kafka, then Justice Lake in order.
My question, Ms. Doherty, is probably pretty straightforward to ask. I don't know if it will be the answer, but what if the FDA has all the information and there's no way for the plaintiff to get her hands on?
Right, thank you. So first of all, that's counterfactual, so that's not the case. The information, part of the exchange that goes on between the company and the regulators under the pre-marketing approval is post-approval reporting. And we would encourage the court to look at all of the federal appellate cases that we've cited in the briefs, whether or not they ultimately go for us or against us. In every one of those cases, you have specific factual allegations that allow the court to assess whether or not there is a federal violation. In this case, in fact, in the appellee's brief on pages 13 through 16, and in the battle of the SIR replies, if you will, all of the information that appellee cites has been publicly available to her prior to the filing of the original complaint in this case. So there's plenty of information out there and available if in fact there is a violation to allege here. And I think as we take a step back from this case and take a step back from the question of preemption, aren't we in a situation where every case may have an imbalance of information? The Supreme Court taught us in Iqbal that the lack of information doesn't allow you to open the door to discovery. There has to be facts adequately pled, plausibly suggesting an entitlement to relief. Those facts are not present in this case. So we don't think the information imbalance, which you may see across many, many cases, and remember, over the years, we've developed techniques to deal with that. There's ways to do investigations, there's statute of limitations, there's the discovery rule. There's lots of ways for us to address that imbalance. The point is that imbalance doesn't exist in this case. There's plenty of information out there. This product has been on the market since 2009. There's a publicly accessible database of all safety reporting that's done on this case. The PMA itself, the safety review by the FDA has been sitting up on that website well before this amended complaint was filed. So the information is out there, and I don't think we can draw an inference. I
don't want to take all my colleagues' time. I think
okay. Thank you, Justice.
Justice Kafka.
Well, I'm confused on the amended complaint issue for a second. I read the SIR reply and the reply brief, and apparently there are examples at least 2 years after this of adulterated product, right? According to the brief, and I have no knowledge if this is true or not, but again, we're at a motion to dismiss stage, that when the adulterated product was used with some of the other people, they had this immediate, extremely painful reaction. If they are allowed to file an amended complaint that says that, does that get them over the motion to dismiss hurdle here? Because we tend to allow liberal amendments in Massachusetts, right? Why, if they allege those facts in an amended complaint, does it survive? Why doesn't it survive a motion to dismiss?
Justice Kafka, because all of the facts that are not part of the complaint, so we got to jump over that, right? So they're not properly in the complaint. We're past that, right?
I agree. I read the first complaint is just a list of conclusions.
Yeah.
The amended complaint adds this idea of adulterated substance, but doesn't provide any factual detail of why it's an adulterated substance.
Correct.
It seems also like a conclusion. The third, this SIR reply is starting to suggest there's something out there 2 years later. That's where I am. So go ahead.
Yeah, understood. So the recall itself, so let's focus on that, right? And to answer the question, the alleged injury in this case took place in June of 2015. The recall happened in December 2017. The amended complaint is filed in September of 2018. The recall is publicly known at the end of 2017. But here's the thing about the recall. It's one lot. It is one lot. When that happens, the FDA is all over you. And I think the reason that the plaintiff's complaint wouldn't survive if they were allowed to replead that is that there's no nexus between what happened in that recall and her alleged injury. There is no factual nexus. Not just that they're temporally distinct, but there's no factual nexus.
She's got, again, and I missed the word you said, there's one line or one lie?
One lot.
One lot, okay.
One lot, yeah.
But she's got to, how does she do a proper adulterated substance complaint? Does she need to introduce blood data about what was put into her body versus what's in the what's in this sink back or whatever it's called? Does she have to do that at that level of specificity, or is how specific does it have? Because does she have access to the chemicals in this stuff? Is that a publicly available data?
There's plenty of publicly available data in terms of the chemicals, in terms of what is in the product itself. Sure. I mean, that information, in fact, is on the label. There's lots of published information about what Sinvis 1 is. Again, this has been on the market. The FDA studied it quite rigorously. But to answer your question, Justice Cochran, I think what we're talking about here is what is a plaintiff to do in order to allege those facts. And if we look across, again, all of the federal appellate cases, whether it's from the 9th, the 5th, the 11th, the 6th Circuit, in every one of those, the complaint has detailed facts. It says, for example, there is a warning letter. There is a 483, what's called a 483 in our business. It's an inspection report where they come in and look at the manufacturing. There is a public safety database that you and I could go on and log on to right now, look up SynVisc-1 and look at all of the complaints, safety complaints about SynVisc-1. And if you look across those other cases, including the 3 Superior Court cases in Massachusetts that we cited in our brief, in every one of those cases, that information is publicly available. The plaintiff is able to muster that information in a way, and again, if it ties to her injury, which is an essential requirement here, that they've been able to allege those facts in the complaint with sufficient detail that the reviewing court can say it's either plausible or implausible. We don't have that benefit in this case because there are no factual allegations other than adulterated, which is an incredibly broad term in this industry. It can mean many, many different things. It's equivalent to saying there's a defect, therefore you're liable.
So in this lot case, in the lot case that you described, someone identified an improper chemical in the product. Is that how was that done?
How is the lot, what's the events that lead to the recall?
Well, somebody identified that the lot, in the example we're talking about, was adulterated, right?
If we're talking about Mrs. Dunn's, the
No,
injection.
I'm talking
Oh,
about,
okay, yeah.
I'm talking about just what you said. There's one adulterated lot or one defective lot. How did they determine?
So I'm outside the record. If you permit me, I can give you an answer to that question.
Okay, well,
So,
I guess I shouldn't go there. So.
no, it's okay. I mean, the general explanation, this is publicly available information. In the quality as it relates to these companies, highly regulated, incredibly detailed, very intensive procedures, there's quality control measures that go all along the way. The company self-reports if there's something that's out of specification, because there's testing that's happening at each stage to make sure that before product is released to the market, that it meets the standards that the FDA has set down and the company itself has set down. If they find something out of spec, they issue a recall. The company will initiate it. Sometimes the FDA has to insist on it, but I don't think that's the situation here. And they go out and they grab all that product off the shelf. So there's an attempt to look at this and to bring it all back. And in fact, on recalls, what you will find is it is quite typical for every company in the FDA to look beyond the specific event. So if something happens day one, we notice that there's a contamination here. They go forward in time and grab everything there, and they go backwards in time to grab everything there. They create this buffer around it. So I don't think the fact of the recall that Dunn is attempting to put into the record of this case would help her if this case was sent back and she was allowed to replead. Because not only is there a temporal difference between her injury and those events, but what happened in that event is not the injury that she's complaining about.
I think Justice Link had a question. I got mute. Here we go.
Gosh darn it, I can't keep, all right.
I can hear you.
Okay, now, all right. My question really has to do with Iqbal and whether or not we're bound by Iqbal, because I think it's been widely criticized. We have, in fact, Massachusetts adopted Iqbal, but I don't know that we're bound by our own, I mean, we've been in a very, very sort of offhanded way in the case that is in our jurisdiction, which if we examine it, is another story entirely. I guess my question to you is, are we really bound by Iqbal? Are we really bound by the federal cases that you cite? I would think not, but there you have it. And then,
No, yeah, I'm sorry, Justice Link. I think the answer is, it's probably a separate question as to whether or not you're bound by Iqbal. Let's put that aside because I don't think it matters.
okay.
The reason I don't think it matters is because in Yanakino itself, this court rejected a pleading standard that essentially was the old Conley v. Gibson standard. That was the Supreme Court case. And of course, the Nader v. Sutrin standard that this court had used for many years prior to Yanakino. But what does Yanakino teach us? It teaches us some of the same lessons that you pull out of Yanakino. 1, context matters. 2, the more facts, the better. 3, even if you allege a violation, it doesn't mean that that violation ties to the injury. So recall that in Yannickino, the plaintiffs in that case, not a personal injury case and not a preemption case, right? But the plaintiff in that case cited to a very specific federal door handle statute, you may recall. And they said that the Ford Motor Company had not followed that. Now, ultimately, what this court did was said, okay, we've got an alleged federal violation here, but as they looked at the counts of the complaint that they ultimately dismissed, right, on the way to kind of getting rid of going to a more of a Twombly standard, they said there was no linkage between the violation of that standard and the injuries that the plaintiffs were complaining about in that case. So even if this court were to say, we're not Iqbal bound, I think the court will follow Yannickino, and I think the teachings of Yannickino apply squarely here. So in the second part of your question, Justice Link, are you required to follow any of the federal cases, federal appellate cases out there? And of course, there's lots of them. They're talking about different things. Is there a heightened pleading standard? Isn't there a heightened pleading standard? Can it be general? Does it need to be device specific? I don't think at the end of the day, that's what should concern this court. I think they're informative. I think the reasoning in those cases is instructive. But I think equally as instructive is the reasoning of some of the lower court decisions in the Commonwealth itself. And we've cited those cases in our brief. So
Yeah, okay. Can I just
yeah.
interrupt you and say, this is my concern with this, which is that it sort of sometimes seems to me like we're putting the cart before the horse here. Because, you know, when I'm listening to you talk about, well, even if they were to amend their complaint to allege this and that, that would be wrong because we, you know, it wouldn't be right because we, you know, their facts would be wrong. And I mean, that seems to me like to be something for summary judgment, not really for a motion to dismiss. You know, that it seems to me that you can't really be arguing about whether or not their facts are right. I think
Well,
you should dismiss
yeah.
it.
No, I understand. And I don't think, in fairness, Justice Link, that is what we're arguing about. We're not arguing about whether their facts are right. We're arguing about whether they are facts. And I think that's, yeah, right?
Okay.
But that's what Yannickino is teaching us. That's what we need to look at. We need to look at facts, and the degree of specificity is going to vary by case, obviously. It's going to vary by case, and it's going to vary by claim. The amount of facts that you need to put into a complaint to allege an antitrust violation may be different than the amount of facts that you need to put in to plead, let's put it at the lowest end of the scale, res ipsa. Mrs. Dunn's complaint is almost res ipsa. Detailed facts about her injury, nothing about how Genzyme violated a federal law that would put you in a position on a de novo review, for example, to determine what that federal violation is, let alone get to the next step, which is that actionable under Massachusetts law? Because there could be federal violations for which there is no state law equivalent claim. And those are kind of cited in the briefs. So we come back to the proposition that all of that background informs this court, and what we're asking this court to do is simply take Yannickino and announce that the standard that should apply for the parties in the courts confronted with a PMA Class 3 preempted claim. For a plaintiff to assert a parallel state law claim, there must be adequate facts in that complaint plausibly suggesting a violation. And that will vary, right? But that is where you start. It's got to plausibly suggest that there's a federal violation. It's got to plausibly suggest that there is a nexus between that violation and the injury. And then we have to plausibly suggest that Massachusetts provides a cause of action that would not otherwise be preempted. So we think all the tools, Justice Lang, for the decision are already in front of the court. And we think Yannickino is the standard, but that standard should be articulated by this court to help litigants and the lower courts in the Commonwealth to understand what to do when confronted with a preempted medical device case. And again, the court obviously is not bound, but we've cited the Dwyer case, a Superior Court case, the Morris v. Rotolo case, and the Phillips v. Medtronic case. Look at that Phillips case. that was Justice Troy did a very nice job of kind of walking through the steps and doing the analysis. So we think all of that is available. We don't have to create any new law, but we should articulate how that standard applies so that there's guidance.
Okay, thanks.
Any further questions? Thank you, Ms. Doherty.
Thank you.
Yeah, sorry, Justice Seifer had a question?
Just one, and that is Attorney Doherty. If you were drafting this pleading, what would you include to make it, to bring it to your level of satisfaction?
I think you would have to include factual recitations that show that there is, again, she's alleged her injury adequately. The facts that aren't alleged is what the violation is that Genzyme supposedly committed. That really is the first step. And, you know, putting myself in the shoes of the plaintiff, she has already put in front of you all the information that's already available to her. My argument is even if she repackaged that on another try, it wouldn't be enough. But if you look,
so if you were the lawyer doing this, you would add a fact about what exactly is defective with the product.
That's exactly right, Justice Seifer. And if you look at
so
some
it
of
could
those,
be as simple as 1 or 2 sentences.
well, it could be. It depends on what the allegation is. So, for example, in some of the cases that we've cited, there's like an implanted device that fails. The doctor sees it. He has to take it out. He says, hey, this failed. They wrote a letter to the company wrote a letter back, or there's a warning letter and an inspection report, something that says, yeah, there's a federal violation here. We don't know whether the plaintiff's going to get relief at the end of the day, but these are the specific parts of the CFR that are violated. Maybe not specific to the device, but GMP regulations, if I put all those regulations and all the guidances on those regulations and all the internal memos of the companies, it would be a phone book. It doesn't tell us anything.
Justice Kafka?
One last question. The defective warning claim, do the warnings for this product indicate that it's a possibility that you're going to have this kind of terrible pain and outcome from its injection?
Yes, the label does warn of what we call injection site reactions. So that could be swelling in the joints, which can lead to pain in the knee. All of that is on the label. And as we pointed out in our briefs, she has a failure to warn claim, but warn of what? And we can't even compare whether what she's complaining what wasn't warned of is actually already on the label. There's a lot of information out there.
When we watch these on TV, the end of the ads on medical products, they go through all these catastrophic possibilities that can happen. Was one of the part of the warning here that what happened to her, as she described it, could possibly happen?
Well, as we understand from the allegations of the complaint, she got 2 injections on the same day by we don't know who the physician is, we don't know the conditions under which any of that was done. And apparently what happened is there was some reaction in her knees that made it difficult for her to walk, and then she fell down and suffered her injury. If you read the label, it talks about the types of local injection reactions that you could get, and it tells people you may experience this. So without understanding more about what she says she didn't know, and quite frankly, we don't know what her doctor told her. There's no allegations in the complaint. And remember, those labels are really for the doctor to have that informed conversation with the patient. So we're not really sure what she was told. But what happened to her can very easily happen without there being any problem on Genzyme's part at all. And that's the difficulty, right? It's not res ipsa. I was injected, I got sore, I fell down, I got hurt. Therefore, you must be negligent. That's not the world we're living in here, nor should it be.
Thank you, Mr. Doherty. We're going to turn to Mr. Dunn.
Thank you. May it please the court, Matthew Dunn on behalf of the plaintiff, Patricia Dunn. I apologize for the technical error that prevents me from joining in the Zoom, but I appreciate the opportunity to be before the court. We see the case, I guess, diametrically opposite than Genzyme does here. In this case, the court is asked to weigh whether an individual who sustained catastrophic and life-altering personal injuries immediately after receiving 2 injections of Synvisc-1 should forever be precluded from utilizing Massachusetts courts to seek redress for those injuries by asserting viable parallel state law claims that do not look to impose any different or additional requirements than those already imposed under federal law. That a Class 3 medical device manufacturer for violating manufacturing and distribution of the product. Genzyme argues that it should, simply because it doesn't want to participate in discovery. When viewed in this light, a simple balancing of the equities in this case tips decidedly in Mrs. Dunn's favor, particularly where such a result has already been accepted by numerous appellate courts across this country.
Attorney
Now,
Attorney Dunn, can I ask you a question before you keep going?
Yes, ma'am.
Do you think that your amended complaint does the trick, or do you think that you could amend it even further to to add some detail that would make it better, improve it?
I think that the complaint, as it's currently pled, is concise and adequate. However, if the court were to disagree, would ask for an opportunity to amend the complaint based on the guidance of this court, because this is a case of first impression before this Commonwealth as to what needs to be adequately pled in order to assert these common law state claims in a Massachusetts court. So,
let me give you an example. So you said in the complaint that the defendant violated certain current good manufacturing practices, but you don't say which ones.
well, Your Honor, the reason for that is because, and I know that my brother had indicated that all this information is public information. We disagree with that. Under federal law, under the PMA approval process, and I think that's at 21 CFR 814.9, Mrs. Dunn lacks the access to Genzyme-specific manufacturing and distribution practices. So that was the reason behind the Bosch v. Stryker case with regards to opening the door to discovery, because the court in that case correctly recognized that the information that Genzyme is saying that needs to be fled here is only in the possession of Genzyme and the FDA. And so anybody in Mrs. Dunn's position who wants to figure out how the product that was injected into her knees and immediately caused, more than simply swelling of her knees or difficult walking, but hip bursitis and systematic pseudoseptic acute arthritis became adulterated. And so that's a locked door for plaintiffs in Massachusetts, save for the ability to proceed through discovery and obtain information as to Genzyme's manufacturing and distribution practices.
Justice Kaplan?
Again, so I listened to you, but you just saying something's adulterated is a conclusion. So do we have any evidence that it is adulterated? Like this chemical methylbacterium thiocinatum, or whatever it is, which was found in the defective lot. Do you have any idea whether the product, do you have any factual basis for concluding that it is adulterated? Or are you just sort of citing the language?
Well, I think, Your Honor, that with regards to, I think an inference can be made that there was something wrong with the product based on the temporal proximity of the injection and the injury sustained. It's almost, and I know my brother disagrees with this, but this is almost a res ipsa locator type of situation where you have...
With medical injections, I take it there's a warning on this product that says a lot of bad things can happen when you inject it into your knee. That's the second argument, the defective warning point. Is that not the case, that one of them is you can have really, really bad reactions to your knees and other things, or is that wrong?
No, that's correct. But what we're saying is that Genzyme knew or should have known that there was something wrong with their product and that it would cause the type of severe, immediate reaction that Mrs. Dunn sustained, which is not indicated in the warning itself.
Mr. Doherty just told us that the reaction, severe reactions are described on the warning label. I don't have them in front of me and I haven't read this in detail. Is that not the case? So that, do we do a res ipsa loquitur that, because again, I watch TV every night and I get the end of those medical ads or all these disasters can happen. Is that not the case with this drug, that there's nothing on the warning label that indicates it can have a terrible outcome?
Not of this substance or this significance, Your Honor. My brother's right that there is swelling of the knees and difficult walking, but systematic pseudoseptic acute arthritis, it's not on there. And I think that if anybody had known that this was an outcome, they may have thought twice about not getting one or two injections of this product.
So you're saying that when we look at the defective warning claim, when we compare the outcomes to the warning, there's no way it could be covered, and therefore something was wrong or the warning was wrong. I'm guessing, is that right?
Correct.
Okay, and then your adulterated product argument, it's not like you have any scientific basis for it, but there's just no possibility that the chemical could cause this reaction unless something else was in it. Is that your argument?
Yes, and that the reason why we can't plead it currently and we can't provide that specific information is because we don't have access to Genzyme's manufacturing and distribution practices because they're confidential under the PMA process.
Mr. Doherty says that the chemicals in this product are publicly disclosed. Is that not correct?
The chemicals used are correct, but what our argument is that an event occurred either during the manufacturing or the distribution process that we don't know what happened because we can't know what happened because it's all subject to how they manufacture and distribute that product is a matter of confidentiality.
But again, the chemicals themselves are publicly, you're saying that there's some stray chemical in there, but you don't have any basis for concluding that, like in that lot case. You're just saying you don't know what the chemical is because you're assuming something was put in there, right?
It's in some way it became contaminated or adulterated based on.
You don't have any medical information from your client that indicates some stray chemical like methyl, whatever that is, was in her system, do you?
I don't have that information at the moment, no, Your Honor.
Okay, all right. I have no.
It doesn't mean it doesn't exist. I just don't have it. And it's
just a cipher.
Yeah. My question relates to the septic pseudoarthritis. You said that was not listed as a side effect?
not that I'm aware of, Your Honor, no.
All right. And my other question is with regard to that adverse reaction, given that it is a septic arthritis, does that suggest or imply that there is bacteria involved?
It may be. The purpose of putting in the information about the 2019 event is to show that the contamination is possible, that it has happened and it could have happened in the past. It's just we don't have the access to the information to be able to draw a direct link between what happened in 2015 at the Genzyme, either manufacturing plant or through its distribution of the product.
Okay, thank you.
Any further questions for Mr. Dunn? You have a little bit of time, Mr. Dunn, if you want to sum up.
Thank you. So just with regards to the adequacy of the pleading, the court's aware of the Iannaccino standard. We feel that we've met that based on the information that is available, that Genzyme, if you just give me a moment, plausibility pleading standard doesn't require a claimant to set out in detail the facts upon which he or she bases a claim. Rather, a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw reasonable inferences that the defendant is liable for the misconduct alleged. And we feel that we've done that in the amended complaint. The factual allegations of the complaint and the favorable inferences that are drawn from it simply need to be enough to raise a right of relief above the speculative level. And we feel we've done that as well.
Mr. Dunn, the factual, could you point me in somewhere, because your amended complaint, I just can't find anything in it except for that the product is adulterated. Is there anything and you describe your client's injuries, but there's nothing factually descriptive about the product, is there?
I'm sorry, when we say factually descriptive, in what context?
Meaning, I'm just looking for a fact. Like, did you mention the septic pseudoarthritis? Did you mention that in your
Yes.
complaint?
Yes.
Okay, so that's there. So that's a fact we've got. And did you mention that that the warning does not mention that?
Not in those specific terms, but that is alleged in different terms.
Okay, and on the adulterated claim, what facts should we look at besides the use of the word adulterated? Is there anything there?
So, as it's referenced in the brief, Your Honor, the term adulterated is a term of art under the United States Code. With regards to supporting facts that show that it's adulterated, again, it's almost a res ipsa type of argument here, where you have, based on the temporal proximity of the injection and the immediate effects of the immediate adverse effects. And the fact that there's an allegation in paragraph 3 of the complaint that Genzyme was the one that was in control of designing, producing, manufacturing, marketing, distributing, packaging, and selling the Synvisc-1 that was injected into Mrs. Dunn. So we feel that based on those factors, the exclusive control and the immediate impact of the event, that this is a type of injury and severity of an injury that doesn't happen in the absence of negligence. So, with regards to the claim that the state law claims are somehow preempted, I'd just like to point out that preemption is an affirmative defense that Genzyme must raise and prove, and to do so, it must show that the claim seeks to impose a different or additional requirement on it that is already required by the FDA and the PMA for Synvisc-1, and that Genzyme has failed to do that. The allegations in the complaint make clear that Mrs. Dunn is simply seeking a damage remedy from Genzyme for violating Massachusetts law that parallel the PMA and current good manufacturing practices. The claims brought do not impose any more stringent safety requirements that currently exist under federal law. Rather, the claims parallel the requirements of federal law and seek a damage remedy. This is precisely the scenario that the Supreme Court found in Moore and Regal, where state law claims pass through the narrow window that avoid preemption. For some guidance on this, my brother pointed out to the Phillips case, but Judge Darsh's decision in Brown v. DePoy Spine that's cited in my papers, and I believe it attached as an exhibit, provides an excellent rationale for why these types of Massachusetts common law claims are not preempted. With regards to the specificity of the pleadings, we'll point the court again to the Bosch v. Stryker case. It's a Federal Circuit case from the 7th Circuit, and would adopt those arguments as well. But in summary, the amended complaint is pled with sufficient specificity and illustrates a causal connection between the Synvisc-1 that was injected into Mrs. Dunn's knees and the personal injuries that she sustained to satisfy the plausibility requirement of I and Aquino when taken as a whole. He's also illustrated that Genzyme has failed to establish its affirmative defense that her parallel state law claims that seek a damage remedy are preempted by the MDNA. Mrs. Dunn specifically requested this honorable court uphold the Norfolk Superior Court's April 22nd decision denying Genzyme's motion to dismiss, or in the alternative, allow her to amend her complaint to conform to this court's decision. Thank you, Your Honor.
Thank you, Mr. Dunn. The matter is under advisement.